Good morning. I'm Paul Truster, program planning lawyer with the Law Society. I'd like to apologize for the late start and to welcome you all to today's program, What You Need to Know About Disability Law. And I'd also like to welcome the bar admission course students who are joining us today. Speaking of bar ads, to thank in particular Alan Trelevin and Alexis Singer of the Department of Education for being particularly supportive and active in the development of this program. Above all, I'd like to thank today's faculty, not all of whom are visibly in place at the moment, obviously, but as you know, continuing legal education is completely dependent upon the efforts of our volunteer faculty in planning programs, in preparing the materials you have in your binder, and in presenting them. And we're deeply grateful to all of them. Well, we're running late. With no further ado, I'll introduce the first speaker, well known to most of you already, David Lepofsky, who from 1988 to the present has acted as counsel in the Constitutional Law and Policy Division of the Ministry of the Attorney General, conducting constitutional litigation and providing constitutional legal and policy advice to the government, including, of course, on leading equality and human rights cases. Please welcome Mr. Lepofsky. Thank you.
I'm delighted to be here with you folks, and I'm particularly worried to see how many victims of the public law section of the bar admission course consider themselves self-evident gluttons for punishment and coming back for more. Despite your best expectations, I will not talk about privative clauses today. I do, however, understand that there would be a plausible reason for you to come here today. You finished your public law exam on Thursday, thought that it wasn't possible to find anything less interesting until you started real estate on Friday. I'm pleased to lead off today's presentation by talking to you about the concept of equality for persons with disabilities. Equality is essentially the organizing theme for today's entire presentation. During our first panel, we'll try to explain and expand upon the concept of equality that I'll outline for you in a relative. Our panel will delve into in a perhaps more practical way. Our second panel will turn to the practical equality issues that will affect you in representing clients with disabilities, how to achieve equality of access to legal services for persons with disabilities who have legal problems and come to you for legal help. The second panel will relate, if you will, to equality, not in terms of the content of substantive law that you will advise clients on, but how to make sure that you can deliver legal services in an effective way to a client who has a disability from a practice perspective. Finally, this afternoon's presentation will round out our examination or our application of equality by focusing in on legal issues that you're most likely to be called upon to advise a client with a disability on. We have an elaborate legal education system in this province and in this country. It has and will train you well to represent the 85% of the public who at the moment do not have disabilities, but it until now has been woefully deficient at training you about the substantive legal areas that are perhaps of the greatest concern to the 15% of our population who do have disabilities. And what we're going to try to do with you this afternoon is to address, albeit in a relatively abbreviated form, some of those. Well, let me begin by talking about equality in the abstract. What does equality mean for persons with disabilities in Canada? Well, this subject was something that you didn't actually really talk about back in the mid-1970s, because back in the mid-1970s, Canada had a constitution but no Charter of Rights, much less an equality rights provision. Canada had human rights codes in every province, which prohibited discrimination in housing, employment, and access to services, but which did not extend that guarantee against discrimination. So the legal concept of equality for persons with disabilities some 15 to 20 years ago simply didn't exist. And of course, we know the common law never respected equality or protection from discrimination in the modern egalitarian sense of the term for anyone. So there was no statutory protection, there was no common law protection, and there was no constitutional protection. Well, in 1993, we've come a dramatic long way. Every province and the federal government all have human rights codes which have been amended to provide broad, thorough, and comprehensive guarantees of equality and protection against discrimination for persons with disabilities. And the Supreme Court of Canada has said that these human rights codes are of a near constitutional status, not just like any other ordinary law, and that they are to be interpreted liberally. Similarly, we now, since 1982, have a constitution which includes a Charter of Rights, and a Charter of Rights which in turn includes a guarantee of equality, and a guarantee of equality which in turn explicitly sweeps within its embrace persons with a mental or physical disability. Well, we have all of these rights now on the books at a statutory and a constitutional level. So the challenge we face now is the challenge of implementation of these rights, making them work. And of course, the ultimate key component in making equality work are lawyers, because lawyers are the people who enable clients to make use effectively of the law. Well, implementation of equality rights for persons with disabilities isn't always an easy or self-executing task. An anecdote depicts the problem. Back in the mid-70s, before the Human Rights Code in Ontario was amended to prohibit discrimination because of disability, the Ontario legislature took its first direction by enacting a law called the Blind Persons Rights Act. And this act prohibited discrimination in access to public services for a blind person accompanied by a guide dog. This is and was a significant concern because people who are blind face mobility challenges, and there are many ways they can effectively conquer them, one of which is by a trained guide dog. The problem is that once you have a trained guide dog with you, there are many restaurants, taxi drivers, taxis, and the like that won't let you in because they don't want a dog there. So the legislature prohibited. A particular woman sought access to a bar and was accompanied by her guide dog back in the 70s, hereinafter known as Elvis. That's the dog. And she was refused admittance because she had a guide dog with her, and she produced her little card that the government of Ontario gave her, personally signed by the then Attorney General, saying that this is against the law. And the owner of the bar thanked her very much and told her to leave. So she laid charges under the Blind Persons Rights Act, confident, no doubt, that the legal system would rally to her defense in what should be a relatively easy case. These were enforced in provincial court through the precursor to the Provincial Offences Act. She showed up in court to testify on trial date, no doubt accompanied by lead Crown witness number 1, Elvis, and entered the courtroom early to be on time, with Elvis at her side, whereupon the court clerk turned to her and said, "I'm sorry, ma'am, you can't bring that dog in here." It's one thing to have equality rights on the books, and it's a very different thing to have them implemented effectively. That's very much, as I said at the outset, what we're going to talk about today, but let me start out by trying to just struggle with what equality ought to mean for persons with disabilities. And to do so, I propose to turn your attention first to the practical reality that now confronts persons with disabilities in this country. Second, to try to identify the purposes which equality seeks to achieve. Finally, to talk about the concept of equality which derives from this reality that disabled people face and the purposes that the right seeks to achieve. Well, why look at the reality confronting persons with disabilities? We do so because our Supreme Court has quite rightly told us in the constitutional context, and I would argue with equal force in the quasi-constitutional context of human rights laws, that fundamental constitutional guarantees should be applied not in an abstract fashion, but in a contextual fashion, having regard to the reality in which they will operate and the reality of the problem in society that they seek to correct. That's why we look at the reality confronting persons with disabilities. Well, what is that reality in Canada? Well, I would make 3 observations about it. The first is that persons with disabilities in Canada constitute a substantial and a substantially disadvantaged minority group in our society. I'd indicated in my opening remarks that persons with disabilities number some 10 to 15% of our population. Despite how many few people with disabilities you may happen to actually see in the high school classrooms that you attended, or the university classes that you attended, or the public transit system you used to get here today, the fact of the matter is we're talking about a very large number of people. But not only are they substantial in number, but they're substantially disadvantaged in status. Some statistics, often statistics are boring, but some statistics make the point. Our society gets unquestionably outraged when the unemployment rate that faces the mainstream of society peaks in the range of 7, 8, 9, or 10%. This is unacceptable for everybody else. Depending on which studies you read, the trend over the past 20 years is that employable age persons with disabilities have faced unemployment rates varying from 50 to 80%. For them, 10% unemployment would be nirvana and not the misery that others would view it. 80% unemployment is the kind of rate that you would only see facing a general population in a third world country. So from the employment perspective, persons with disabilities very much live in a developed country with an underdeveloped country's unemployment rate confronting them. Similarly, studies show that persons with disabilities, if underrepresented on the employment roll, are overrepresented on the rolls of those dependent on social assistance and among the poor. One study in the late 70s, jointly conducted by the CNIB and the federal government, documented that fully 40% of blind or partially sighted, seriously visually impaired Canadians lived at or below the poverty line, and that was before the previous government decided that the poverty line should be raised. So we're talking about a group that's not only substantially unemployed, but substantially impoverished. As well, we find that people with disabilities face systematic exclusion from the mainstream of Canadian life. Job descriptions are written as if they were to be filled by able-bodied persons. Collective agreements are written as if the people who will be working in the workplace will only have the needs of able-bodied persons. Public transit systems are designed as if they were only going to be used by able-bodied persons. Buildings are built as if they were only going to be used by able-bodied persons, and so on. And this is a long-term legacy that people with disabilities have faced. So that, if you will, is the first reality they faced. The second reality that people with disabilities face on an individual level is that disability for them generally, frequently, does not equate with inability. That is to say, the advent or birth with a disability does not necessarily render a person incapable of independent living, of effective employment, of raising a family, and participating in the mainstream of Canadian life. Some disabilities create more barriers than others, but with most, if not all, disabilities, there are a myriad of ways to learn to function independently despite the disability. Sighted people read by looking at ink print on the page, using Braille, or tape-recorded books, or if they're partially sighted, large print, or speech-synthesized output of computers, and so on. Hearing people communicate by the spoken word. Hearing-impaired people may use real-time translation, sign language, lip reading, and the like. The list goes on. Now, this was the case in the mid-70s, long before we had these legal rights. However, it has amplified in the 80s and 90s, because over the 80s and 90s, much as we are all familiar with the technological explosion in the realm of computers used by mainstream folks, there has been a similar explosion in the technology available to persons with disabilities. In the 1970s, a blind person to read had to have books transcribed onto Braille by volunteers trained to understand how to write in Braille, or to have volunteers read books onto tape. Now in the 80s and 90s, with new computers, we have document scanners that can intake printed text and turn it into computer data, and Braille printers that can churn out Braille, or speech synthesizers that can churn out speech, so that a blind person's capacity to have independent access to printed materials without using a sighted reader, without using a Braille transcriptionist at all, has become quite common. And the technology gets cheaper and better all the time. So the second reality facing persons with disabilities is that of an enormous capacity to participate in the mainstream of Canadian life, increased and to be increased, and methodologies that are coming out. Put simply, disability does not equate with inability at all. In fact, the concept of disability, I'm fond of saying, is a relative one. One is not either disabled or able-bodied. These kinds of categorizations, while we use them for legal purposes, are practically irrelevant. And indeed, that is why the in vogue term that we use is not disabled persons, but persons with disabilities, because a person with a disability may not themselves be a disabled person. But I'm fond of pointing out that this is all quite relative. If I as a blind individual were to get into a car with a sighted person, I have a disability relative to them in terms of driving. Though given how some people drive, one might say, not much. On the other hand, when a sighted person comes to me for legal advice, that sighted person having no training in law, they are disabled relative to me in terms of understanding, knowing, and being able to work with the law. It is only the fate of, if you will, able-bodied chauvinism that leads the one to categorize people as disabled, that is to say, the ability to drive the car, and not the ability to practice law. Indeed, if we use the yardstick of the ability to practice law, the vast majority of Canadians would be the, quote, disabled folks, and there'd be very few of us who would not be. So that's the second reality facing persons with disabilities. But the third reality flows from the first two. The third reality facing confronting persons with disabilities is that there is rampant in society attitudinal stereotypes and attitudinal barriers which impede full participation in society's life. No matter how more enabled disabled people get, the common expectation among able-bodied persons is that disabled people are poor, pitiful, helpless, dysfunctional charity objects. And the only exception to those are the one or two superstars who wheel their wheelchairs from here to the moon or something like that. And this attitude barrier, the vicious cycle goes like this. 40, 50 years ago, you didn't see disabled people with disabilities participating in the mainstream of life. So our parents' generation, or our grandparents' generation, when they assumed positions of authority as school principals and designers of building and government officials and employers and managers, they just assumed that disabled people couldn't, wouldn't, didn't want to participate in the mainstream of life. So they went about designing school programs and building buildings and designing jobs and building public transit systems in a fashion that would cater to the needs of those they thought wanted to participate, able-bodied persons. Well then, they created another inaccessible world. Their children grew up seeing that inaccessible world, going to school without having people with disabilities around them very often, and going to jobs and not having people with disabilities around them very often, and so on. And they just assumed that that was, quotes, normal, unquote. So they in turn headed about creating more barriers for full participation for persons with disabilities. So uninformed and discriminatory attitudes beget barriers, physical organizational barriers, and the physical organizational barriers beget more negative attitudes. And the cycle goes on, and the only thing that will crack that cycle is a vigorous enforcement of the guarantee of equality. And for that reason, I turn to my second area I said I would discuss. I turn from the reality facing persons with disabilities to the purposes for guaranteeing equality. The Supreme Court has told us that to understand the meaning of an important legal right, we must identify not only the context in which it will operate, but the purpose for which it was guaranteed. Well, the purposes for which equality is guaranteed for persons with disabilities, I would argue, include these. First, to ensure to persons with disabilities equality of opportunity to fully participate in Canadian society to the extent of their individual abilities. Full participation is the key. Second, to require that people with the ability of persons with disabilities be subject to a fair and accurate by persons considering hiring them or otherwise involving them in access to services, facilities, and the like, and not to have them assessed by broad brush stereotypes and presuppositions. And thirdly, to promote a society which accommodates the differences that we all have, a society which does not assume that we are all physically, psychologically, or attitudinally clones of each other, identical replicas, with some group of freaks and weirdos who don't just fit in the minority. Our conception is not that disabled people are different and therefore less, but that everybody in society is different and that accommodation of everyone's needs is the essence of equality. Well then, how do we take these purposes for equality and turn them into practical legal standards? For that, I turn to the third and final aspect of my presentation. What does it mean to guarantee equality to persons with disabilities? Well, the concept of equality has evolved in Canada for all. And it is evolving still, and I would suggest to you, for reasons I'm about to outline, that concept, its latest evolution, is driven primarily by persons with disabilities. Let me take you back in time. If we go back to the first era of struggles to understand equality in the modern time, that would be the late 50s and the 60s, predominantly in the United States. There, the core issue on the equality agenda was that of racial equality. And the problem confronting racial minorities, particularly in the States and particularly blacks, was a society that was essentially had the American equivalent of apartheid. There were two streams within one which could be the more desirable one, where whites were, and the less desirable ones, the separate and unequal buses or schools or washrooms or whatever, for blacks. And the claim at that time that the victims of inequality put forward was, we want to be treated the same as the benefited group. To treat us the same is to achieve equality. to treat us differently is inequality. It's discrimination. And that became the touchstone of equality in the late 50s and the 60s. And it seemed to work pretty well for a while. It was a touchstone of equality which was, to some extent, not entirely, picked up by the next major trend in the equality battle in Canada and in the States in the late 60s and the 70s, and that was the claims of the women's movement. Women are being paid less than men, are getting less job opportunities than men. Women want to be paid as much as men and have access to the same jobs as men. Women want to be treated the same. To treat them differently is to discriminate. To treat them the same is to achieve equality. Now, I will acknowledge as I take you through this brief history of time that all of this is subject to exceptions, variations, and the like, but you'll see why I'm doing it as I proceed. So by the end of the 70s, we thought that we sort of had understood equality and that we got it right. But in the early 80s, it was discovered that equality just wasn't adequately promoted by this concept. And oddly, the group that seemed to bring this to our attention the most were religious minorities, and particularly religious minorities in the workplace who couldn't work Friday night or Saturday because of their religion teaching that they are the Sabbath. This was particularly brought to bear by a woman named Teresa O'Malley, who was employed at Simpson Sears, and who was, while employed at Simpson Sears, became a Seventh-day Adventist. Seventh-day Adventists teach that you cannot work Friday night or Saturday. It is a core belief of their religion. Simpson Sears provided that if you want to work there, one of your work shifts has to be Saturday. O'Malley brought a human rights complaint claiming discrimination because of creed. Now, under the 1950s and 60s first stage conception of equality, we had a problem here, because nobody said to Mrs. O'Malley, we don't want you here because you're a Seventh-day Adventist. They didn't know what her religion was, and they didn't care what her religion was. What they said is if you want to work here, you do the same thing as everybody else does when everybody else does it. And that is equality. And applying the old standard of equality, we are going to treat you the same as everyone else. That's equality. What you want, Mrs. O'Malley, is to be treated differently, to get Saturdays off. And that would be discrimination. So the old concept of equality didn't serve Mrs. O'Malley particularly well. Well, in the face of that, human rights boards and ultimately the Supreme Court of Canada said, no, wait a minute. Maybe the old concept of equality doesn't go far enough. The old concept of equality assumed that similar treatment was always equality and differential treatment was always discrimination. Maybe sometimes it should be the other way around. Maybe sometimes when you treat everybody identically, apply to them the same rule or practice or requirement, you create a norm or a rule which has the effect of excluding a particular human rights protected minority from the workplace participation. In this case, you have a rule that applies equally to all. You got to work Saturdays as part of your shift. It is adopted for bona fide business reasons. There's no claim that it was pretext for screening out people who were Seventh-day Adventists. But it had the effect of screening them out nevertheless. It would have been, from the perspective of the complainant, it was the exact same as putting up a sign saying no Seventh-day Adventists need apply here. The Supreme Court of Canada said that where there is a neutral rule adopted for bona fide business reasons, but which has discriminatory or adverse discriminatory effects, this prima facie is also discrimination. It's called adverse effects discrimination. And it is on the basis of this that the Supreme Court of Canada said that where such arises, the employer has a duty to accommodate the needs of the complainant, to enable her to participate in the workplace. But that duty of accommodation is not absolute. It is only to the point of undue hardship. So as of 1985, we thought we had come to phase 2 in our understanding of equality. And in phase 2, equality claims fit neatly into two possible boxes, one or the other. Over here, my left, your right, we have the direct discrimination box, the 1960s conception of equality, treating people differently and when you should have treated them the same. In the case of human rights speak, if you tell somebody I'm not hiring you because you're black or because you're Jewish or whatever, that's direct discrimination and that violates the code. But over here on my left, or my right, I can't tell my left from my right anymore. Sort of like politics these days, right? But on my right, your left, we have the second box. That's the adverse effects discrimination box, the O'Malley box. And there, we have a rule which treats people the same but has discriminatory effects. And there's a duty to accommodate. It's over here in the adverse effects discrimination box that we drudge around and find a duty to accommodate. And we thought at this point, 1985, that we now had it right. We had equality straight. It would serve everybody's interests. But then along came people with disabilities. And we shook everything up. And I would say it is the advent of people with disabilities near the forefront of the equality agenda that requires us to rethink things. Why is that? Well, let me give you a hypothetical to show how the mid-'80s phase 2 approach to equality starts to fall apart. Let's say hypothetically we are a blind lawyer. Let's say hypothetically the blind lawyer applies for a job at a law firm, public or private sector. And let's say at the job interview the employer says, look, you're blind, how are you going to communicate in writing with everybody here? We use computers. And we use email and we do memos and all that kind of stuff. How are you going to function? And the blind lawyer says, well, it's very simple. You spend whatever, $1,000, and you buy a speech synthesizer and some screen reading software, and you plop it in the computer, and it reads what's on the screen or on the disk. Fine. And the employer says, well, that's all very interesting, but we don't have to buy that for anybody else, and we're not prepared to buy it for you. These are tough times. You could hire lots of sighted people. What do we need you for? See you later. Now, let's go to our human rights analysis. Which box does this fit into? Well, at one level, you would go to the direct discrimination box and say, does it fit in there? And you'd say, well, look, the employer said, I'm not hiring you because you have a disability. Well, isn't that sort of a clear case of direct discrimination? And the problem is, though, the employer says, look, I'm treating this person like anybody else. The person can't read what's on the screen. We give them what we give everybody else, and the guy can't do it. So he can't do the job. Human rights doesn't require us to hire someone who can't do the job. So forget it. Doesn't work. The person with disability says, wait a minute, well, I'm just asking you to accommodate my needs. Put this board in. And I said, no. Sorry, that doesn't fit into this box. You want a duty to accommodate. You look not in the direct discrimination box. You got to look in the adverse effects discrimination box. So then you go rummaging over to the adverse effects discrimination box and you say, well, there's, is this a case of adverse effects discrimination? The employer may say, well, wait a minute. Adverse effects discrimination arises where the employer never turned their mind to the human rights criterion like race or sex or religion. It never even came up. Here, the very first thing that came up in the conversation was disability. We were talking about it. And we said, we're not hiring you because of your disability. So that can't be a case of adverse effects discrimination. What have we got? We got a mess. What's the solution? Well, how all of these two discrete boxes were best shown to collapse and fold into each other was in the the leading human rights case on disability and equality under human rights legislation. And that was a case in the late 80s called Huck against Odeon Theaters. Mr. Huck was a wheelchair user. He went to a theater to see a movie. There was a ramp in front of the theater, but when he got inside the theater, he said, I'm just going to park my wheelchair here in the aisle, hit the brake, and watch the movie. And the theater said, you can't do that. You got to sit in one of the seats because we don't want you blocking the aisle. And Mr. Huck said, well, I don't want to. So fine, move one of your seats and I'll wheel my wheelchair into that slot. And the theater said, no, our seats are all bolted down. We'll hift you into the chair. Mr. Huck, probably on a date, said, thanks very much, but I don't need two of your goons lifting me and dropping me into one of your chairs. That is not equality, much less dignity. So we filed a human rights complaint. And the court, Saskatchewan Court of Appeal, unanimously agreed that he was discriminated against, but divided as to why. Two judges, constituting the majority opinion, said, the presence of this condition where you've got to sit in the chairs is a neutral requirement which was not based on any intent to discriminate. It has adverse discriminatory impact, so there's a duty to accommodate. So that fit it neatly into the adverse effects discrimination box. So they had to accommodate him, and they didn't. But the plurality judge, the third judge, said, no, wait a minute, this is not a case of unintentional discrimination. This theater knew disabled people could be coming in. They've got a ramp right in the front of the building. Where were they born? Come on, wake up. You got a ramp? That means people in wheelchairs are coming in. You can't say that everything was completely unintentional, that by inadvertence only. These people knew what they were doing. It was intentional discrimination, and to rectify it, they've got to accommodate him. Well, Mr. Huck didn't really care which one he won by. He got a duty, he got accommodated. And the accommodation's easy. You move the chair, the wheelchair isn't going to roll down the aisle because, as we all know, the floors in any theater are so sticky you can't move anyway. Okay? So it's easy. So what has happened is persons with disabilities situation boils down to the essence of equality is accommodating needs so that you can fully participate. And from the perspective of people with disabilities, there is little, if any, care whether you've got an adverse effects discrimination box or a direct discrimination box. The old theory assumed that these were either or. We have shown that they merge. And that, frankly, our equality analysis would be advanced if we stopped wrestling with these arcane legal distinctions that make academic writers go to heaven with article production and reproduction of articles, but don't really help people figure out what equality means. What we need to do is to essentially turn all of this on its head and say that for persons with disabilities to have equality, the core of their guarantee of equality is a right to be accommodated. Anne Malloy, counsel at Arch, I think has made a leading contribution in this field by suggesting that we stop talking about the duty to accommodate and start talking about the fact that human rights guarantees persons with disabilities a right to be accommodated. And that if we get rid of all of this sort of prima facie case analysis and the direct versus adverse effects analysis, we'll go a lot further. Well, let me take the last 3 minutes that I have with you to talk a bit about the duty to accommodate. You will have in the materials a paper which I've done on this. The right to be accommodate is not an absolute one. It has limits, and the limit is that of undue hardship. We know certain things about undue hardship. The first is that the party seeking to advance a defense of undue hardship has the burden so to prove. So employers, who fail to accommodate do so prima facie at their peril. They've got to prove that they couldn't. We'll deal with some specific examples in our panel in another couple of moments, but the duty to accommodate, or the right to be accommodated, may impose duties not only on the employer, but on a trade union, where trade unions participate in the creation of barriers to full participation. They may be found in a collective agreement, for example, or impede or limit the efforts by employers to accommodate the needs of a person with disability. The union may also have a duty to accommodate. The complainant may also have a right to be accommodated by the union as well. With respect to the kinds of considerations that might add up to undue hardship, the one that gets most readily raised in the case of persons with disabilities is cost. Cost too much to accommodate you. A couple of very brief observations about cost. Firstly, the employer has to prove that the cost will be incurred. Secondly, the employer has to prove that the cost can't be afforded. And in considering this, the Supreme Court has said it's got to be more than de minimis costs and more than de minimis efforts. But as well, in assessing whether an employer can afford to accommodate, it is not simply enough to say that the employer has spent every last penny, they've got a deficit, and now they can't afford to meet the needs of this person with a disability. Because that presumes that human rights for persons with disabilities is the bottom priority. That is not what a near constitutional right is all about. What I'm fond of doing if I'm cross-examining a respondent in a duty to accommodate case who claims they can't afford it is to ask them to produce their budgetary figures on how much they spent in the past year on wine and cheese. It shows the point. The priorities that, or low priorities that is given to human rights for persons with disabilities and the cost concept can well be a proxy for prejudice. And finally, it's important in the cost context to note that costs also bring with them benefits. By expending the money, the employer may accrue the use, or does accrue, the productivity of the employee with a disability. The employer may well accrue with it tax benefits in the sense of tax deductions, so the cost, net cost may be on half. But the employer may acquire other benefits as well. If I can give just a small example, I have a document scanner in my office which I use to scan text and scan print and convert it into text. I use this as a reading machine. But a number of my colleagues from time to time who have a 10-page document that they want their secretary to edit and they lost the disk will come trundling down and saying, by the way, would you mind scanning this? I, of course, being undyingly helpful to my colleagues at all times, find out what I can extract in exchange for their request, and then verily throw it in the scanner and scan it. Now, the cost of that scanner came out of a special government fund to pay for accommodations for persons with disabilities, but the benefits don't all accrue to me. And the same goes for many. I mean, in front of the Government of Ontario Attorney General's building, there are 3 doors, one of which is the disabled access door. With a little button you push, it swings open and it hits you, right? Well, I will tell you that 90% of the people who use that door have no disability, at least before they hit the button. The last thing I should mention in terms of the concept of equality, before I conclude, is that on the latest agenda of equality for everybody, in all the designated groups, and especially persons with disabilities, is employment equity. Employment equity goes beyond the usual means for achieving equality, but its aim is nevertheless to attain equality for persons with disabilities. Put simply, if you think that having a vigorously enforced human rights code and Charter of Rights is going to prevent discrimination because of disabilities, you would be sadly mistaken. Vigorous employment equity is necessary to reverse the discriminatory trends that are so deep-rooted in our society and which are the product, generation after generation of exclusionary practices. It is sometimes claimed that this constitutes reverse discrimination. And I can say only 2 things about that. The first is the Charter and the Human Rights Code both say as a matter of law that it doesn't. But secondly, what is criticized as reverse discrimination is best viewed in a different light. We've always had employment equity. We've always had affirmative action. It's just that up till now we've had a different designated group benefiting from it. Designated group is called white, able-bodied men who got preferential access to jobs, ability notwithstanding, for a very long time, as a result of which you end up with figures like 80% unemployment for people with disabilities. What we're doing with employment equity is essentially repealing that affirmative action program and replacing it with one that may counteract its effects, leveling the playing field. And while we can discuss this later, I'm fond of pointing out that they who criticize employment equity and object to it in principle are usually objecting to it predominantly because they're afraid that their own affirmative action program has gone away, and people who've been excluded till now are going to get the benefit of one for a little while. Anyway, to conclude, I mentioned that between 1976 or the 70s and the present, we have acquired all sorts of new equality rights protection, and I've said that we should interpret it in light of the purposes it seeks to achieve. Back in 1980, when the Charter of Rights was proposed, it initially did not include a disability rights clause. Like other human rights laws, people with disabilities had to fight to get in. I had the good fortune when I was a law student to be able to participate in the lobby to get disability into the Charter. And when testifying before Parliament, I concluded my presentation in a way that I will conclude today, by focusing on the aims of equality for persons with disabilities. It is often said that justice is blind. That is something we seek to achieve. What equality for persons with disabilities is about basically tries to turn things around and says that if justice is to have the opportunity to experience blindness, then blind people and people with other disabilities should also have the opportunity to experience justice. Thank you.
David Baker and Vic Willey to join us at front here. Those of you who were here sharp at 9:30 know that we were not sharp. We were late in starting, and consequently our break will likely also be late. I estimate it will be at around 11:15, not at 10:55, as stated on the agenda. We'll begin in just a moment. Thank you. Mr. Goudge, of course, is managing partner of Gowling, Straley & Henderson and practices general litigation for many clients, including the Office of the Premier of Ontario and others listed in his biography and the materials. He's also a bencher of the Law Society of Upper Canada. David Baker has been executive director of the Advocacy Resource Center for the Handicapped Arch since 1980, which, as most of you know, engages in test case litigation, law reform, and public education. And Mr. Vic Willey is executive director of the Centre for Independent Living in Toronto, Incorporated, which is an independent living resource controlled, run, and staffed by people with disabilities. Thank you.
You want me to run this one? How do you want to do it? I think you're the chair.
I gather I'm the designated chair, so as the person with the least knowledge of this subject on the panel, I'm delighted to fill that role.
Me? Wait till you hear me, Vic.
What I'm going to do, we haven't discussed this, but what I propose to do is to put to the panel for their views and the questions that are latent in the examples, the 8 examples that we have in front of us. You will all have them. The panelists will all have read them. I propose to ask each of the... let me just read them briefly to you one at a time, and I'm going to first ask David Baker to begin. The first example is Mizet applies for a filing clerk position at Company X. Mizet is profoundly deaf and cannot use a regular telephone at all. She's refused the position because the filing clerk sometimes has to take calls, it is said. David, do you want to begin the discussion on that sort of real-life example?
Sure. I think there are 2 levels to this one. The first one is the human rights issues, and the second one would be, assuming Bill 79 is passed as it has been promised, it will be passed, the employment equity legislation. There are employment equity issues which arise from it. Let me touch first on the employment equity issues, and then I'll pass on the human rights questions to others in the panel.
May I interrupt just long enough to say that the questions are not in the material?
Oh, sorry, that's my fault. I apologize for that. I will read each of them. Okay. But let's carry on and we'll discuss them one by one.
Obviously, a major barrier, as David mentioned in his presentation, for persons with disabilities is the fact that job descriptions have been designed and entrenched often in collective agreements based on assumptions that people will not have disabilities and therefore will not be prevented from performing a wide range of functions on the job. Now, that does not happen to be reality for persons with disabilities, and therefore these job descriptions represent a major barrier. Under the employment equity legislation, an employer will be required to do an employment systems review to identify what are the barriers, and therefore something very fundamental in most workplaces will be examined as a potential barrier, that is the job descriptions which exist. The employer will be required to develop a plan, in the case of unionized workplaces, to negotiate a plan with a trade union. The union obviously will be in a difficult position with respect to this particular question, since many rights which unions have acquired, notably seniority, are dependent upon the existence of these job descriptions. The employer then is required to use all reasonable efforts to remove these barriers over the course of implementing their employment equity plan. So from the standpoint of employment equity, it is possible, at least in the context of individual disability situations, to anticipate a much more flexible workplace. But there are human rights issues, and I'll perhaps pass those back to you, Mr. Chair, and through you to David, perhaps.
David, do you want to comment on the human rights
I think the other
dimension
two
of this?
members of our panel should be required to change their name to David to avoid confusion. From a human rights perspective, this is an accommodation issue. Clearly, and I should indicate that in my opening remarks, I talked about how the different strands of thought have collapsed in the equality context. If you're working with the Ontario Human Rights Code, you'll find that the duty to accommodate persons with disabilities applies equally in the case of direct discrimination. You'll see that in Section 17 of the Code, or in the case of adverse effects or constructive discrimination in Section 11 of the Code. Either way, however you spin it, there's a duty to accommodate issue here. The duty to accommodate issue here arises in that there are job duties which job requirements which the person may not be able to meet because of their disability, and it may either involve a requirement that they be given an accommodation to assist them in doing those duties, or a restructuring of job descriptions to assign those duties to other people. So there's two things. Either you just cut that part of the job description altogether that you say is unnecessary to the job and say hire the person anyway, or the requirement. Or alternatively, if there are particular duties the person cannot do because of their disability, particularly if they're not essential duties to the job, you reassign them to other workers and reorganize your job specs. As David Baker just said, this is sort of an example of an endemic problem that these job specs are written this way. In a large workplace that is not unionized, it may be very easy if you have a lot of clerical staff to say, okay, look, you over here are going to do a little more of this and you over there is going to do a little more of that. And the work still gets done. Where a collective agreement impedes that, you then start turning to the question of whether the collective agreement has to give way to the human rights duty to accommodate.
Vic, do you want to give your thoughts on maybe the kind of accommodation that might be made in a circumstance like this?
Well, I'm in a unique position because we employ people who have a disability, and we face this sort of thing all the time. I think just a simple common sense approach that's been put forward, although it has legal and technical repercussions, of just changing the job specs. We have staff standing in for each other or doing different things or doing things according to their ability, and it seems to work quite well for us.
One of the things that's kind of entertaining if you ever get a case like this is to ask whether anybody's ever read the job specs before they were hired, because most people find in most workplaces that the job spec is something somebody filed away about 20 years ago. In fact, if you ask who wrote it, they usually say Fred wrote it, and yes, where's Fred? And, well, he's retired and has moved somewhere else. I mean, it's irrelevant to the job itself. which may enable you to further show that there's no undue hardship to anybody in changing things around.
I mean, one approach that can be used with employers is to say, would you hire a deaf secretary? And most employers would say, well, no, they have to secretary answers the phone. And then the comeback is that why do all secretaries have to answer the phone in a firm with more than one secretary? One can answer the phone all the time, or two can, and two can do the other duties. So it's good to step back and think practically and not just reflexively act with the sorts of thoughts we have around job descriptions.
One of the ironies, I guess, in this area is while we talk about equality for people with disabilities in terms of accommodation, compare this. My hypothetical I gave during my talk on a visually impaired lawyer needing adaptive equipment and being told, oh, well, that's some sort of special need. Compare that to a hypothetical big law firm that hires a hypothetical senior partner, and then the office manager comes in and says, do you prefer a secretary who takes shorthand, or do you prefer using a dictaphone, or do you want a laptop or two, or do you want a cell phone, or what? None of that's called duty to accommodate able-bodied people. That's just how you do business.
It's part of the managing partner's job description.
Right, exactly. And they're the ones with all of those things.
That's right.
But at some point, one gets concerned that while the accommodation concept is legally central, that a lot of this is what you do for other people anyway, and the fact that people with disabilities may get singled out for a lot more questioning about why do you need this than others might gives rise to some deeper concerns about attitudes in the workplace.
Yeah, it seems to me that's one of the primary lessons from this particular example, that is, job descriptions, formalized or not, are matters of bendability in virtually every circumstance, and it is easy to make them as bendable in a disability context as it is in the everyday context in which they are bent all the time. I don't know, Paul, do you want to have questions for the panel on each of these, or should we just move on to?
I would think with 8 fact situations, you will be under some pressure to move on.
Yeah, we have 8, and we may not get there. We'll go till 11:15.
Sure.
The second fact situation, let me read it. Mr. B is employed at Company Y in the shipping department. Mr. B has been diagnosed as manic depressive. During the past 6 months, he's been off work an average of 4 days per month because of stress and because of medical appointments. Company Y has now given him 3 written warnings with regard to absenteeism. The last warning says he will be terminated if the absenteeism situation does not improve immediately. David?
Well, under wrongful dismissal law and in the trade union context, arbitration decisions, on the issue of absenteeism, certain standards have emerged as to the point at which absenteeism will constitute just cause for discharge. I think the real question here, and perhaps the reason why it's on the materials, is to raise the question as to whether or not in a human rights context the issue of absenteeism will be revisited, both from the standpoint of the extent to which absenteeism is an accommodation, and also the question of the point at which absenteeism becomes a question of capacity to perform the essential duties of the job. I can throw it back at that point.
Leaving the question unanswered.
Absolutely.
I bet he wants me to answer it now, right?
Okay,
That's right. It was a clear case.
I agree with David.
That the question exists.
I don't think anybody could have put it better than David. We have been litigating this, I in my official capacity. I'm supposed to have said at the outset that I'm speaking in my personal capacity, but I guess that can relate back to the start of the morning. Anyway, does anybody care? Anyway, in my professional full-time workaday capacity, I've represented the Human Rights Commission in a number of cases that deal with people who have to miss certain shifts because of religious holidays. The way you would walk this one through a traditional human rights analysis is the requirement of full attendance or attendance in accordance with whatever the policy is a neutral requirement, but which can have discriminatory effects on people with certain disabilities, such as in this case, and therefore it would give rise to a duty to accommodate. So the real question is, in the end, can the employer accommodate this person's attendance needs without undue hardship? And that requires a consideration of a whole mess of considerations, like how much you need continuity in the work. Could you reallocate to this person duties which are can be completed without the same kind of timelines? Can you replace this person when they're away and they'll just pick up? In other words, to what extent does the job lend itself to other people picking up when they're off? And in doing a cost analysis, it would also include a consideration of what are the costs of covering the person in their absence. If this person was in a situation where, for example, they weren't paid on their day off, then on their missed days, then the employer doesn't lose anything. If they are, then there are cost questions that arise there. But the important thing is to step back from this and see is that most job attendance requirements are designed or were designed historically on the assumption of the perfectly healthy, perfectly functional person with no family requirements to be anywhere but at work on a full-time basis. And that as soon as you depart from that, somehow there's something wrong. Well, we've started to learn about things like maternity leave or parental leave. We're starting to look at family time off for dealing with kids who are sick, that kind of thing. This is just another manifestation of that, and a flexible work arrangement. The final point I'll make is that in assessing undue hardship, one of the things that you would infuse here is a comment I made in my opening remarks, which is looking not only at the costs of absences and coverage, but the benefits. A workplace that requires everyone to lockstep appear at 9 o'clock a.m. and lockstep leave at 5 p.m., whether or not their kid is in serious illness or whatever, is not a workplace that necessarily creates positive morale. And on the other hand, flexible work arrangements may yield to greater productivity and greater worker morale. So the kind of flexibility this person might need might actually add to workplace productivity rather than subtract from it.
Vic, your comments on?
Nothing much, except that
prototype?
I'm wondering why a situation would get to this point at all. I mean, it says here, because of stress and because of medical appointments. Well, what is causing the stress? The man is manic depressive. Maybe he does a week's work in 2 days, God knows what, and you don't want him around the other 2 days. Maybe maybe there's something here that's happening that's causing the stress, and an accommodation can be made if they simply sit down and discuss this openly together, without going to litigation or without going to the point where he's going to be fired. At our place, we have, as David was mentioning, we have a flex time, and it's not unusual for staff to be in the office from 7:30 in the morning until sometimes 9 o'clock at night, due to the nature of the work and what they're doing, but also due to their individual needs. And it's not infrequent for staff persons, for example, to have a time when she's maybe going to need a lot of trips to the ophthalmologist, and we just say, well, just make it up in the evening, or make it up on another day, or sort of thing. So I think that these things often can be worked out between the employer and the employee. Often I think employers tend to be frightened of employees with disabilities and don't even want to broach the subject.
If I can just follow up on one brief point there, just to show how the collective agreement thing can click in here. If I can take your example of the worker who takes some time off and then wants to work it off, make it up at other times. One of the two leading cases in the area of union responsibilities, a case called GOHM, G-O-H-M versus Domtar, where a woman couldn't work Saturday shift because she was a 7-day Adventist. She agreed that she could do the work on Sunday. The company agreed that the work could be done on Sunday without disrupting any productivity. The fight was over how much she'd be paid on Sunday. She was in a bargaining unit. They all thought the contract required her to get time and a half on Sunday. The employer said, I don't want to pay time and a half on Sunday. You could work Saturday at straight time. The woman said, the complainant said, I'd be happy to work Saturday straight time. Pardon me, Sunday straight time. I just want to be able to work. The union insisted that if she was to work Sunday, it had to be at the contract rate of time and a half. The employer was not prepared to agree to the time and a half. The union was not prepared to agree to straight time. The employer fired her, and the commission brought the claim, and it ultimately resulted in damages equally being apportioned against both of them. The board finding that either the straight time accommodation or the time and a half accommodation would be defensible, would be required under the code, but neither the employer nor the union had done enough to accommodate. The significance of that is that in a non-unionized workplace, the suggestion that, well, you take time off and you work it off when you can come back in on the weekend or whatever may be easy to do, but when you get a collective agreement union situation in there, it becomes more complicated, and it can give rise to an obligation on the company and the union to sort out a way to make sure this can work.
David Baker?
Yeah, just a note of caution. I mean, I think absenteeism is an interesting issue when you approach it from the standpoint of accommodation, because if you've had the opportunity to look at the guidelines which have been issued by the Ontario Human Rights Commission, page 7, it refers to the cost standard. And essentially what it says is that cost will only constitute undue hardship when the cost would alter the essential nature or would substantially affect the viability of the enterprise responsible for the accommodation. Now, if you take an IBM or a Xerox, if you have someone who's absent for a good long time, maybe in the department that might be noticed, but across the enterprise that wouldn't be that substantial. So I think absenteeism is going to be an interesting issue in the way it evolves, because I think it will be a case where other considerations beyond the accommodation consideration come into play. Sort of a voice of caution perhaps on this one as well.
Well, it's, I think, very fair to say, David, that the sort of legal context for that starts from a premise of regular attendance, and if regular attendance is somehow threatened as one projects into the future, then under arbitration case law or wrongful dismissal case law, there is a risk for the individual. It's obvious that the notion of accommodation pushes flexibility into that paradigm in a way that will take some doing, but there are pressures there, there's no question. I mean, we've had comments from all three at both the legal and the sort of attitudinal level. The attitudinal level obviously is a major issue as well. I think of this kind of issue most immediately in my context, not so much in terms of a disability issue, but an accommodation for time having to be taken for other reasons. Those of you who are in the bar admission course who will be heading into practice will face the pressures of 1,800 billable hours and the need to have some accommodation in a number of contexts for that, and you will know the kinds of attitudinal pressures that will drive against that. It's the same kind of thing.
I'd predict, though, that absenteeism is an area where I think it will be dealt with legislatively in concert with some examination of disability benefits. There will be some attempt made to bring those into line, so there's some consistency, albeit you want to give the flexibility, particularly in transitory situations.
Okay, let me read the third example. Ms. C is a quadriplegic. She has recently been hired as a management trainee at Company Z, a major international manufacturer. Her employer has provided her with adapted equipment, including a specialized computer, and has also made arrangements for the company nurse to provide her with attendant care as required. Ms. C is learning her job effectively, and her supervisor has a good opinion of her work. However, she has been placed in a department where 2 longtime middle managers have been recently let go by Company Z due to downsizing. Some co-workers, friends of the middle managers who lost their jobs, have asked why all this money being spent on you when cutbacks are costing others their jobs. Because of their comments, the situation for Ms. C in the department is quite unpleasant.
David.
David?
Well, I agree with David again. We are used to, firstly, this is a real problem. It is not unusual for workers who have a disability and who get accommodated get all sorts of comments like this made to them. And you know, we started to understand issues of harassment in the workplace predominantly in the gender context of sexual harassment, either in the case of overt sexual solicitation that is unwanted or sexual touching that's unwanted, but also in the context of inappropriate and unwelcomed remarks that make an environment which make it not only an unpleasant but an unacceptable place to work. And in a lot of male-dominated workplaces, when women were first introduced to them through equality initiatives, the first women to go into those environments would face the same kind of harassment. As a result of this, human rights law has evolved to acknowledge that harassment because of a protected ground such as sex is itself an act of discrimination. And similarly, harassing a government or private sector employee, here in this case a private sector employee, because they have an accommodation, whether by the manager or a coworker, is itself, I would argue, a form of actionable harassment. And we know from the sexual harassment context that there is a duty now on employers, not only themselves not to sexually harass, but to make sure their staff doesn't, and to adopt anti-harassment policies. The way I like to put it when I do duty to accommodate training within the government is to say that the duty of an employer to accommodate includes a duty to provide an employee with a disability with a welcoming environment in which to seek and receive accommodation. Otherwise, you're talking about people who could well be, this can affect their capacity to perform the job, their sense of feeling there, and eventually drive them out of the workplace, and it really does happen. With respect to the particular, one might respond, my final observation is one might respond by saying, well, you could sympathize with people who saw their manager lose their job and yet see this person come in with all this adaptive equipment. Well, while superficially one might think that that's sympathetic, I unsurprisingly don't find it sympathetic at all because of the premises it's based on. Firstly, it assumes that this person was hired or their accommodation was paid out of the very dollars taken from the salaries of the people who were laid off. And that, of course, is a presumption which is at least unproven and probably doubtful. Secondly, the duty to accommodate is a legal requirement. And to harass a person for having their legal rights honored, legal rights which historically are not honored, essentially, if that's to be allowed and be subject of sympathy, you basically turn all of these lovely guarantees and make them worthless because people who actually try to receive accommodation will have to endure harassment and will drive them out of the workplace.
Vic?
Well, you know, I think Martin Luther King said something like, you know, laws won't change what's in people's hearts, but it'll change what they do about it. But, you know, that's not really true. Now, with this sort of thing, disabled people have, you know, everything's fine and nice when you're the nice little stereotype, quiet, childlike disabled person. I remember when I came to York University, I used to get all these smiles from, it was mainly women, you know, it's the nicest bunch of people that I had ever met in my life. I realized I didn't know any of them, and after a while I understood what it was. They were giving you that little smile that's usually reserved for babies or puppy dogs. And, you know, because you were invalid, an invalid, and so it goes, and you can ignore that sort of thing. But, you know, when push comes to shove and it starts costing dollars, behind those smiles and that, there's a hell of a lot of hostility, and I think a lot of it's based on fear and misunderstanding. But nonetheless, it's still there, and in situations like this, it's going to come out. And there's sort of two kinds of disabled people. I mean, many of us have been socialized into dependency and into being quite meek and that, and often that's the way you get along in an institution or in the world when you're in a powerless position. And then there's the other kind, like myself and some of my colleagues here today, that realize we have to fight all the time, and it's very easy to be mistaken for an angry person because there's a lot to get angry about. So I think that the disabled community is going to have to get ready for this kind of hostility. One of the ways to get ready for it is to have to know the champions we have up here on the panel here that can fight for us and understand what the legislation and the laws are, and that we do have a right to these jobs. And the other things are deeper and subtler, and I'm not sure how they're going to be. It's I think we're going to see a lot more hostility as these laws kick in and people are being put in to positions just like this. This will be replicated over and over again. We'll see hostilities from the unions. We'll see them from co-workers, and I'm just hoping it will all evolve properly and well, but I think there's going to be a difficult period coming.
David Baker?
Yeah, again, blue skying a little bit. Just mention there are countries which approach the accommodation issue a little bit differently. And that is, for example, in Germany, employers which do not hire persons with severe disabilities pay into a fund, and out of that fund come the monies for these kinds of accommodations. So there are different ways of approaching it from the one we've adopted here. We're just starting to see what this means to impose on the private sector this obligation and to enforce it systemically through employment equity, and it's going to be interesting to watch how the private sector responds. But I think in the short term, I think Vic's quite right. There's going to be quite a bit of this kind of negative response and harassment, as David has said. Whether it works through that this obligation holds or whether a different mechanism has to be developed will be the question we'll be watching.
I guess I would suggest to you, if you advise employers or unions, that it isn't enough to just sit there and, if something like this comes to your attention, to try to correct it. Pardon me, as is the case in the sexual harassment context, the employer has an affirmative duty to go out to, and I would argue, to the extent that there's unions that may have control over some of this, perhaps them as well, it's an interesting question, but to do workplace education and to announce as a policy not only the requirement of accommodation, but the providing of this welcoming environment, so that if anything like this happens, the people who are making the harassing comments should have already been made aware that that kind of behavior is unacceptable, and it should be considered something which the employer should be taking steps against them for this kind of conduct.
Let's move on then to the fourth example. It's this: Mr. D has a significant learning disability. He applies for a job as human resources manager at Company Q, a retail store with 3 locations and 75 employees. Mr. D has a degree in personnel management from a recognized university. During the interview, he discloses his disability and says he cannot read written documents. He would require materials on tape or a reader to assist with written materials. The proprietor of Company Q replies that he cannot afford to provide this support. After the interview, Mr. D contacts his counselor at Vocational Rehabilitation Services, Ministry of Community and Social Services, who faxes Company Q a letter saying they can provide a tape recorder and 1 day's reading assistance a week for 6 months, but cannot make a longer commitment. A few days later, Mr. D receives a letter from Company Q saying that they were impressed with his qualifications, but there were a number of well-qualified candidates, and another has been offered the position. Vic, any comments on that situation?
Well, and I'd go back and, first of all, if I was Mr. D, I'd do it differently. I would, when I disclosed my disability, I just wouldn't bang it out on the table like that and say, balls in your court. I would say, you know, now I have this disability and I can't read, but I can get these materials on tape in a matter of a couple of days. I can do that myself. And I've already contacted my voc rehab people, and they've agreed to supply, you know, come with some goods already at hand. I know that my lawyer friends here will say, you know, there's a duty to accommodate, and I'm sure there are other legal technical things that fall on the employer here, but I think it also behooves the person with a disability to, it's an interview and you want to present yourself in your best light, so let's not let the disabilities, it frequently does in life for those of us with a disability, overshadow everything. I think that he has a duty also to put his disability, his best foot forward, as it were, and present himself in the best light. So maybe to go back and rejig that first would help the situation a bit. But that's as far as I'll go on that.
David Lepofsky?
I agree with those observations. One thing is to talk about the legal obligations, but another is for people with disabilities themselves have to be aware of the barriers that exist out there, and the first way to avoid having to file a human rights complaint is to get the job. and therefore there is some value in anticipating what kind of barriers the employer might be concerned about or needs the employer might be concerned about, and providing them with this stuff. Be that as it may, we have a candidate here who is qualified but for a need for accommodation, so we are in a situation where if a complaint was filed, the employer would have to show undue hardship. And this example talks about a tape recorder and readers. There would be a need to start exploring other options. I would describe the use of a text scanner, which, I mean, to give you a sense, these things used to cost, the document scanner used to, about 3 years ago, they cost $7,500. They now cost $2,000, and they're much quicker and better. That's in 3 years. 1980, they cost 50,000 US. I mean, you saw them at the Smithsonian, okay, that's about it. And they didn't work very well. But in any event, so the employer has a duty not only to look at those accommodations the employee puts forward, but also to look into other possible accommodations that might be there that the employee doesn't know about. Because this employee walking in the door may not know what's going on. For example, this place of employment may have almost all of the documents they produce might well be on email or on computer, at which point they may not need a reader almost ever, because the same technology a blind person uses, a person with dyslexia, for example, can use if they're able to use a keyboard and so on. So that while as a practical matter you tell the individual, the complainant or the applicant, potential complainant, that they better know about this stuff before they get there, the employer just cannot pass it back that way and say, well, the option you've put forward is something we can't accept, so we're not going to look at any other options.
David Baker?
Yeah, I think the important issue here, apart from the practical issues that Vic and David have referred to, is this issue of other sources of funds. And under the code, the duty to accommodate, cost is a factor, but mitigating against that, expressly stated in the code, is the fact that other sources of funds are to be taken into account. And often this is very, very difficult to determine just exactly what sources are available, because programs are constantly changing. So if you're in the position of advising an employer, that employer is assumed to be aware of those programs, is assumed to have made application and received those funds when it comes to toting up what would constitute undue hardship. The programs often are not terribly rational or terribly accessible to employers, but nonetheless the amount that they would have received had they gone through the filling it in a triplicate and so on, involved in getting to those monies, will be taken into account when assessing the undue hardship.
There may, for example, be volunteer services available. The other thing that occurred to me as I'm thinking about this, is we've got a place of employment with 75 people. They may have, I mean, not everybody is working full tilt all the time. I mean, there may be the odd clerical staff who has a certain amount of downtime, and they could be used to do some reading. And sometimes, it's with my experience, a number of people really quite like doing that and appreciate a little variety.
The lesson of creativity and accommodation, I think, is clear.
Well, you see, we're requiring management in the business world to be creative, and I know that is an undue hardship. And it's counterproductive, so I mean, anyway.
That's certainly novel. Okay, example 5. Ms. E applies for a position as a receptionist at a large public hospital. She is interviewed and offered a position. She's told that as an entry-level receptionist, she will have to work all 3 shifts for a number of years, and that full-time regular day shift is only available for receptionists with more seniority under the collective agreement. Ms. E is diabetic, and her physician advises her that working shifts for several years will be damaging to her health. Who wants to lead on that?
I'll take.
David?
Here we're sort of following up on the job description issue raised in problem 1 by adding the seniority issue to it. Often persons with a disability are not able to perform an entry-level position and are qualified for other positions within an organization, but because they can't get over that first hurdle, they are not able to get into the organization. So the issue of seniority has been raised as a potential barrier. I should say, too, that seniority is also a significant protection for persons with disabilities who are fortunate enough to have the seniority. But here the question is whether or not an accommodation could or should be made to permit a person to work the day shift. The case of Renault in the Supreme Court of Canada decided, if there was any doubt, that human rights can and will take precedence over seniority provisions in a collective agreement. This has caused a fair amount of consternation within trade unions, particularly amongst counsel for trade unions. I think we need to emphasize that the accommodations we're talking about are very specific to a particular set of facts and would not go very far at all to undermining the whole concept of seniority. Nonetheless, for trade unions, this is perceived as a major problem, explaining why a person who visibly does not have a disability and may not choose to disclose that they have diabetes, how that person comes to be on the regular day shift when someone with more seniority is still working the evening or night shift is not an easy task for a trade union to deal with, and I wouldn't want to minimize that. This issue in an employment equity context is further confused because as part of the brokering that went on to get an employment equity bill, trade unions were assured that seniority in relation to layoff and discharge would not be treated as a barrier for employment equity purposes, and in a proposed amendment that would be extended in many circumstances to other issues of seniority, so that seniority may not be perceived to be a barrier in the employment equity context. It clearly remains a barrier in the human rights context, and how that will play out in terms of litigation and so on is somewhat problematic. Why don't I leave it there? I know David has strong feelings about these issues as well.
By addressing this, I ensure that I'm not only disliked by management, but by unions. And that's another way of developing the concept of equality. And I know for a fact that I'm not liked by too many bar admission students after Thursday, so life can be pretty lonely. I start from a relatively straightforward assumption, and that is a person with a disability who walks into a place of employment should carry with him or her the same amount of human rights entitlement, whether that place of employment is unionized or not. And more particularly, where a union is present, that should not, and is certified, that should not ipso facto deprive that disabled person with a disability of a measure of their human rights. Certainly that's not the purpose of trade unionism. However, the problem arises that had there not been a collective agreement here and not a union here, this individual wouldn't have had any problem. The problem arises from the fact that there is a union here and there's a collective agreement and it has a seniority clause. And seniority rights are not given by God, whoever he or she might be, but rather come from a contract. And you cannot contract out of the Human Rights Code. If an employer can't discriminate on their own, then they can't bargain with a union to be able to discriminate any more than they could on their own. All of this would make sort of common sense, but it poses some problems for some people. With respect to the specific problem, we have a system of job allocation called seniority. It was not adopted for discriminatory purposes, but it may have the effect of excluding people with this disability from working at this place in that context. And therefore, there is a duty to accommodate. And because the seniority system is the product not of management action alone, but a joint agreement by the manager and the union, they both have a duty to accommodate subject to undue hardship to either of them. The union will claim that this will undermine seniority and that that is undue hardship. The answer to that question requires a functional analysis and not an abstract one. When you mention seniority, members of trade unions understandably get their backs up, and I fully understand why. I mean, this is considered to be an important part of a collective agreement. I don't take away from that, that sense of its importance. However, there's several considerations that offset this. Number one, not all seniority is only contractual. It's given by contract and can be taken away by contract. Secondly, not all seniority rights are absolute. Every collective agreement has exceptions. Exceptions to seniority for union officials, for jury duty, for all sorts of things. You go over and look at the Labor Relations Library, you'll see different collective agreements have different clauses, every single one of them. So creating a disability-based exception to seniority is not somehow dramatically new. In fact, the parties could well, had they turned their mind to it, have agreed to it in the first place. As long as the exception leaves the overall seniority system for most people more or less intact, but does get rid of the discriminatory impact, I would argue that there is no undue hardship. And to show that, the aim of seniority is to prevent sort of wanton, arbitrary, unfair managerial favoritism. And that's understandable, but an exception for people who can't work the other shifts because of disability would not lead to such. You could design a seniority clause that would achieve this aim without that kind of favoritism or tyranny of the foreman.
Vic?
I'll concur with the two Davids on that.
It's clear that this kind of problem does add to the already substantial set of barriers, the barrier of the trade union, because in a circumstance like this, the trade union is going to have great difficulty. The reality is, though, that with the arguments David makes, it's almost impossible to say that the concept of seniority is in any way impaired by the accommodation that is suggested by this example. Nonetheless, the political reality is there that the duty on trade unions in a collective agreement context to accommodate is one that is causing the trade union movement considerable angst. Paul, I know it's 11:15. We've done 5 of the 8. That's just a pass mark. I'd propose that
Conditional.
Conditional. that we stop now and break for coffee.